Marc Stevens, author of Adventures in Legal Land and Government Indicted. My website, markstevens.net, where we're working to bring about a voluntary society, one visitor at a time. And, of course, the radio show is the No Say Project, live every Saturday from 4 to 7 Eastern Standard Time on the Liberty Radio Network, LRN.FM. And what we're about here on the No Say Project is evidence. I made some pretty strong allegations against a federal magistrate, just a lawyer with a stupid robe on, but that's the title that they go by. And I had mentioned that he's a liar. The man lied. And then I'm going to give you the documentary proof. Because unlike people like this guy and his minions, his employees, his subordinates, I tend not to form an opinion until I have all the facts, or at least enough facts that the facts tell a particular story. And that's what we've got here. I'm going to show, and this is institutional. We could demonstrate this every day of the week. This is a very easy thing to do. It's absolutely institutional because, hey, these guys, their services are so good that they have to threaten you. And they have to coerce you to pay them. That's why they got the gun. I love that Photoshop job. So let's get into this. Let's look at the actual evidence. So what we're going to do is a little background. Like I mentioned on the show, this is in regards to a petition to enforce an IRS summons. And they were not able to produce any evidence whatsoever when we met with them in the St. Paul or in the Bloomington office of the IRS. Jeffrey Wagner, professional liar, and it turns out the magistrate told us that he lies even about his name, and that's in the document I'll show you in a moment, where Jeffrey Wagner was asked a question directly: "What evidence do you have to prove the Constitution and the Code apply to me?" He referred to it as a frivolous argument. This is called a straw man. It's a lie. It's a false statement. A question is not an argument, and damn it, I hear it almost every day. Don't fall for it. And I had a prosecutor the other day tell me that, well, a question can be an argument. No, it can't. Not unless English is like your fourth language. No. A question is not an argument. They're two separate things. But let's get to the actual evidence, something that someone like Eric Holder just does not have. None of them do. So let's get to this. This is the court document. I mentioned, yes, I did gimp out the case number. It's still an ongoing thing, but it was filed recently, 4914. This is page 14 of 10. Now, a magistrate cannot grant or deny a motion to dismiss. All they can do is make a recommendation to the judge that they work under, and then the judge makes a decision. So this is very, very important. This is 10 pages long. I'm only going to go through one page because to go through this, to do a full analysis of this would bore you to tears because it would be like 2 hours long. So suffice to say, I only need to show this one example to impeach the integrity that this man may seem to have. I don't believe he has any integrity whatsoever. Well, then again, I'm kind of biased because, well, he's a government. Yeah, he's the government. But it's critically important to understand what's going on here by looking at the page number, because we made a factual challenge, a very serious factual challenge. And this man, this lawyer, uses three sentences out of 10 pages. So right there's a problem. 3 damn sentences. So let's dissect this. Let's see the story that the documentary evidence we have tells. Respondent factually challenges the basis of the petition in Wagner's declaration by making a conclusory statement that Wagner has a history of bad faith and dishonesty. You'll notice the quotes. He's quoting directly from the motion to dismiss. Okay? Respondent provides no facts to support this serious allegation. Therefore, the court will not conclude that this allegation is true and respondent's factual challenge fails. This is the part I want to focus on here. Respondent provides no facts to support this serious allegation. Without going into any more detail, let's take a look at the motion to dismiss so that you can decide for yourself. Let's see, is this an accurate statement? Because if you think for 1 second that just because a judge has it in a report or it's reported that is what actually happened, boy, you need to get your damn head examined. You really need to engage in some critical thought. You need to engage yourself in a little bit of the system before you make any kind of opinion on it, because you're woefully ignorant of how these things work. Just because the magistrate wrote this doesn't mean it's true. But let's go to the actual motion to dismiss that he's responding to here in this recommendation. Remember, respondent provides no facts to support the serious allegation. So let's go see motion to dismiss. This is the document that he's responding to. Jeffrey and his supervisors are currently being investigated by the Treasury Inspector General for Tax Administration by Jeff Stotko of the St. Paul office. That's a statement of fact. Jeffrey has a history of bad faith and dishonesty. Where have we read that? That is a conclusory statement. Jeffrey has claimed numerous times in person and in writing that I raised a frivolous argument. That's factual statement number 2. I repeatedly asked Jeffrey for evidence the Constitution and Code apply to me, and Jeffrey deliberately called the question a frivolous argument. That's statement of fact number 3. He then handed me an 80-page document containing frivolous arguments. That's factual statement number 4. I think, 1, 2, 3, yeah. Okay, Jeffrey has refused to identify the page number where asking for evidence is a frivolous argument. That's another statement of fact. And then last, he cannot because questions of evidence are not arguments, frivolous or otherwise. See? These are statement of facts. Now, does that look like a true statement to you? Does that look like the judge is being honest and telling you the truth? Respondent provides no facts to support the serious allegation. And there's the quote, has a history of bad faith. So we know exactly where he pulled that from. It's right here. This is where he pulled it from. What do we call this? Jeffrey claimed numerous times in person and in writing I raised a frivolous argument. I repeatedly asked Jeffrey for evidence the Constitution and Code apply to me, and Jeffrey deliberately called the question a frivolous argument. The facts tell the story. These are our statement of facts. This shows where we can prove beyond any doubt this is what the judge is pulling his statement from. So when he writes the respondent provides no facts to support the serious allegation, he's a liar. I don't care that he graduated from Yale or wherever, okay, I went to Yale's. I don't care how many years he spent as a prosecutor and calls himself honorable. Just like every other government employee, he's a liar. And this is what they do. This is why 11 years ago I wrote in Adventures in Legal Land, and I have on the back cover, it's the three-monkey defense. Whenever you hit these people with indisputable facts, they just lie and say they're not there. So now you've got indisputable documentary proof that this, just one more magistrate, is a liar. And that's what you get when you deal with these people. They have absolutely no evidence their constitutional laws apply, and when you bring it up and when you ask questions for that, they say, I'm not going to argue with you. It's a lie. It's called a straw man. They're lying to you. No one's arguing. And anytime you engage these people, you'll find that out when you ask them for the evidence. And now you can see why only 3 sentences out of 10 pages, because all he starts doing is going through, he's going to claim the Constitution of the United States is the supreme law of the land. But he doesn't provide any proof it actually applies. So that's why he has to lie. Respondent provides no facts. Yeah, where are your facts the Constitution applies? See? Nice double standard there. He's lying, saying we only make conclusory statements when it was Wagner and his attorney that did that. Ay vey, these people. So again, another example of the institutional dishonesty that you can expect from people called government. Because hey, like we mentioned before, governments are just men and women providing a service at the barrel of a gun. They have no voluntary support. Zero. That's why, that's why they have to threaten you to pay them. And if you think I'm full of crap on this video, if you think that there is another rational explanation for why the judge said that no facts were presented, call the show. Oh, and while you're formulating a reason to troll or to disagree with this, there are 2 objective records of the meeting with Jeffrey Wagner. We have an audio recording that was done digitally. And then Jeffrey has his own analog recording. So, he had a micro cassette recording. So, it's not an issue of whether the facts are true or not. He said there weren't any facts. And so if you want to say, well, he didn't believe it, yeah, there's a CD to prove it. So, good luck. But I do encourage critics to call the show or contact me at markstevens.net and show me where I have made a factual error, because I'd be more than happy to correct it. And for those, again, in general, if you think that there's evidence proving the Constitution and laws apply to you just because you're physically in North America, please contact us contact me on the radio show every live every Saturday on LRN.FM, and please present your evidence.